Hi, I'm Mark Nelson. I'm one of the writer-analysts here at Wolters Kluwer Law and Business in our federal securities products. And this is the second in a series of 4 videos on the recent SEC crowdfunding proposal. Today's topic will cover essentially 2 items. One will be the aggregate securities limit and some ambiguities that arise in the Jobs Act with respect to that limit. We'll also cover some ambiguities that arise in the Jobs Act regarding the investor limit for individual investors in crowdfunding offerings. First of all is the aggregate securities limit. In general, crowdfunding offerings are at the very low end of the dollar thresholds for exempt securities offerings. Here, the proposal would limit them to no more than $1 million in aggregate amount of securities. However, there are some ambiguities in the Jobs Act regarding how we get to that aggregate securities limit. These arise really from 2 different provisions in the Jobs Act, which amended separate provisions of the Securities Act. In Securities Act Section 4A6, for example, the Jobs Act amended that statute to provide that crowdfunding transactions would include, and here the key word is include, crowdfunding and other exempt offering amounts. Whereas a new section added by the Jobs Act, the new section is Securities Act 4 capital AG, directly conflicts with 4A6 by stating that there should be no limit on crowdfunding offerings raising capital from other exempt offerings. In its proposed regulation crowdfunding, the SEC, at least as tentatively, decided in favor of the more lenient provision in Securities Act Section 4 capital AG. And so for purposes of the proposed crowdfunding regulation, capital raised in exempt offerings outside the crowdfunding context would not count towards the $1 million aggregate securities limit for a crowdfunding offering. As an example, the SEC offered a situation where an issuer sells $800,000 of securities pursuant to Regulation D. These Regulation D securities would not count towards the aggregate limit for crowdfunding transactions. But the proposal did go on to suggest an example where an issuer in a crowdfunding offering offered $800,000 of securities, and in reliance on the crowdfunding exemption, that issuer would then only be able to offer an additional 200,000 securities in that offering, in that exempt crowdfunding offering, within the same 12-month period. Also of note here with respect to the aggregate securities limit, for purposes of reaching the $1 million limit in a crowdfunding transaction, the SEC's proposal says that issuers could exclude from that amount any gifts or any other funds raised through some of these non-securities based crowdfunding sites or other types of donations. And that brings us to the second topic today, and that is the limits on investments by individual investors in exempt crowdfunding offerings. In general, there are 2 brackets of investors that we're talking about here. One would be persons whose annual income or net worth are below $100,000, and those whose annual income or net worth are $100,000 or above. Some ambiguities arise with respect to the investor limits because the Jobs Act repeatedly uses the word "or," and it also doesn't necessarily make clear whether one should use the greater or lesser amount of one's annual income or net worth. For purposes of its crowdfunding proposal, what the SEC has said is that in calculating the investor limit, one needs to look at both annual income and net worth for investors where both their annual income and net worth are under $100,000. In that case, those investors would be allowed to invest the greater of $2,000 or 5%. And with respect to which amount they would use, whether it's the annual income or net worth amount, they would use the greater of those amounts in applying the 2,000 or 5% limits. For investors who have either net worth or annual income of $100,000 or more. And here the proposal did retain the word or. They would be allowed to invest a maximum of 10% of those amounts up to a maximum of $100,000. I think it's interesting that in her statement on the day the Commission issued the proposed crowdfunding regulation, Commissioner Stein did note that the Commission had mulled whether to use the greater or lower language, especially with respect to investors in that lower bracket. And she did note in her statement that the lower language might still be a possibility. In fact, the crowdfunding proposal does put out for public comment whether the Commission should reconsider using greater or lower in its final rules. Also, in testimony to the Senate Banking Committee, not too long after the Commission issued the crowdfunding proposal, Keith Higgins, the director of the SEC's Division of Corporation Finance, reiterated the language used in the proposal that an investor in that lower bracket could invest $2,000 or 5% of the greater of annual income or net worth if both their annual income and net worth are under $100,000. And that concludes today's video, talking about the aggregate securities limit and the investor limits under the Jobs Act mandated rulemaking, creating a proposed securities-based crowdfunding option for issuers and investors. This is the second in a series of 4. We'll do 2 more, one on the requirements for issuer compliance and another one covering intermediaries, including funding portals. I look forward to talking to you then. For now, I'm Mark Nelson at Wolters Kluwer Law and Business.